Hey everybody, welcome to American Courts. Got a bunch of people in the chat room already. Hey, LD Henderson, got Donald in here. Um, Throw the goat. Good morning. Good morning. Got Nancy, Linus, Sivo Girl, Amanda Panda. I saw you earlier, Amanda. We got also, let's go, Ian. We got in there today. Jay's here. Everybody say hi to Jay. Make sure you say hi to Jay. Um, Got a whole bunch of people in there. Thank you so much for coming in. We got some good ones for you today. We got a quick one with Judge Boyd. We got one from Clayton County, Georgia, Judge Hayward, and then we got a Judge Simpson one today that was really interesting. It's a little long one, but it's okay. We don't mind long ones. So we're going to jump into the short one from Judge Boyd and then on to Clayton County first. Thank you.
Is calling 2024 CR 2331, State of Texas versus Yia Cardinus. Can I have parties announced for the record for the state? Defense?
John Young.
And are you Miss Cardinus? Did you understand that you're charged with theft under $2,500 enhanced? Because the state is proceeding as a repeated count, range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Can we go off the record for a moment? All right, so I'm looking at her history because I'm trying to multitask up here. There are prostitution charges, theft charges, which may or may not be related to the prostitution charges. Has anybody talked to her? I don't know if people just want her to do, or she just wants to do her prison time and be done. But if she just does her prison time and be done, we're going to be back here for prostitution charges and more theft charges. All right, so you would prefer to just go to prison and do your time?
I mean,
Well, I will tell you, people saying this courtroom probation is difficult, and it is, but it's supposed to be designed to rehabilitate people. But what I can tell you, if you have a drug problem, which usually nobody grows up and says they want to be a prostitute, right? Because that's dangerous. It's dangerous with regards to diseases out there. I always tell people there's super gonorrhea now. There's no cure for it. You never know who it's going to be. Is it going to be somebody who's going to want to kill you or something? And you end up being a part of a Lifetime movie, or somebody discovers a serial killer and you're their latest victim? Or either you end up getting some bad drugs or you OD and somebody has to identify your body. So if you want, I will follow this agreement and give you the 3 years in prison if the evidence is sufficient, or I can try to get you help. But what I can tell you, the help you need is inpatient treatment. So it would be inpatient treatment.
well, what kind of inpatient treatment would that be?
Out, see, you can't write your own program.
Yeah.
Let me just tell you. You can't write your own program because writing your own program hasn't worked for you. Because if it would have worked, guess what? You wouldn't have all these prostitutions. You wouldn't have all these theft cases. You wouldn't be here. So if you want the just to go along with the 3 years, I'll give you 3 years. But unless there's some sort of intervention in your life, it's not going to work.
Well, I was recently just put on bond, like, I believe it was 2 weeks ago, and I was on full house arrest.
So here's the thing. You have two choices. In my understanding, they gave you two choices. You can either do probation, and it's going to involve inpatient treatment because you need it, or either you're going to prison. And I always tell people when they make the choice for prison, time will pass whether you're in the prison or not. The question is whether or not you want the time that's passing to somehow change your life and put you on the straight and narrow. I don't think when you were in elementary school, people saw you and said, oh, she's going to be a prostitute, and still something in your life happened along the way where you were using drugs and you started selling your body and then all of these other things. But what I can tell you, you need inpatient treatment. That's what you need. But if you're going to continue on this route, is your mom still alive?
Yes, ma'am.
Your mom may end up having to identify your body. Somebody gonna find a body in some field in San Antonio. Maybe somebody will have reported you missing, and then your mom or somebody's gonna have to identify your body. So if you want to do the 3 years in prison, I will give you the 3 years in prison. But if you want the court to give you probation, I will give you probation. Choose now.
Take the 3 years.
All right. All right. So according to the plea bargain agreement, you're proceeding on count 2. Punishment is to be assessed at 3 years in the prison. There's a $2,000 fine. There are no applications. They're taking in consideration 2024 PF 07597. Did you understand that to be the plea defense?
Yes, Your Honor.
State, is that the plea? Defense is, I'm sorry, Ms. Cardinus, is that the plea? Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? After reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty, and the court will find the enhancement true based upon your plea of true and based upon state's exhibits 1 and attachments. Are we proceeding with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Your Honor, unfortunately, the person that, so to speak, sucked her into this lifestyle was her husband.
Mhm.
So he is currently serving time, I believe. And she just wishes to put this whole business behind her.
All right, the court will sentence you to 3 years in the prison. There's to be no contact with minors, no contact with Esmeralda A. Valdez. Take in consideration 2024 PF 07597. Give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney?
Yes.
Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right. Is that your mom or?
No.
Okay.
There is no way in the world I wouldn't have picked probation. They could sentence me to 10 years of probation versus 1 day in prison. I know I can play nice, and I'd much rather get on that probation. All right. Well, we're going to jump over to Clayton County. Judge Hayward gets into the guy pretty good here, so let's see where this one goes.
Is Keith Barber. You were before this court for no license, concealing the ID of a motor vehicle, another no license, no insurance, or expired or invalid license plates or decal, following too close, all on the 17th day of October 2023. You were sentenced to 12 months on probation. You have 2 months and 17 days remaining, and your probation was told because you failed to report on November 15th and December 15th of 2023, February 27th, March 15th, April 3rd, April 15th, and within 10 days of May 2nd of 2024. You last reported on February 6th of 2024. You failed to pay your fines, fees, and supervision fees in the amount of $2,339.03. You have made no payments to your obligations to the court. All right, talk to me, Mr. Lynch.
So Judge, I did want to make clear from speaking to my client, he did indicate that he did want to stipulate and accept the recommendation from Ms. Chang. But as far as the non-reporting, I believe there were some issues with, he just moved back to Georgia. He had been reporting, I think, by phone from Florida. Is that accurate? So that was, and there may have been some misunderstanding on his part as far as when he needed to report next. But that means,
Mr. Barber, when I do phone and mail report, you know what I say every single time? It's not really phone report because they have too many people and too many folks trying to call them. So the best thing to do is to get 12 stamped addressed envelopes and take the form that they give you and put 12 copies in there. And every time you need to report, fill out that form, go by the post office and drop the form in there. That's what I explain every single time. So I'm not sure how you could have messed that up. You just couldn't find the post office, couldn't afford a stamp. What was going on?
I mean, I was living in Florida, Yana,
And they don't have post offices in Florida? Last time I checked, I know the post office is in bad shape, but they still got a post office or two.
Yeah, I understand that, ma'am. But I was kind of getting in touch with my probation officer. She never told me to report only but one time, and it was recent. I was told to report by phone.
Okay, first of all, sir, you got Miss Chang. She is the most experienced probation officer that we have. Not only is she the most experienced, she's probably the best that we have. And I'm not saying that to denigrate any of the other probation officers, but she's been doing this so well for so long that nobody questions it. So when you tell me you got Miss Chang, but you didn't understand what was going on, I really can't believe you.
No, it's not that I don't understand what was going on. It's just where she told me that I don't have to report in person.
Okay, I probably told you didn't have to report in person. If I said phone and mail report, I told you didn't have to report in person, but you do have to report by dropping the letter in the mail on the days when you're supposed to do it so it gets to her. Now, if you fail to go by the post office, you're just trifling. Yeah. So all these excuses, how old are you, sir?
32. I don't have an excuse. I know I did it wrong.
You do not have an excuse. And so what you're not going to do is try and put it on Miss. No, I'm sorry. And I don't even care if you say I was unclear.
No, I'm not putting on. I know I was at fault, though. I'm not putting on Miss.
Okay, then. So then you just messed up on probation. You didn't report. Stop with all this. Well, I didn't know. I wasn't sure. I didn't get a date. All of that rigmarole. No, sir. You're 32 years old. Get it together. When you planning to get your life together? These are traffic offenses. All we asked you to do was pay. That meant you could have been out there working construction or forklift or lawn maintenance. I don't care what you do. Plumbing, HVAC, any of those things. To make the money, pay your money, drop your money and your report form in the mail and get it done. But you sitting around growing a beard and can't get it done, and you back in jail on some traffic stuff. Traffic, driving, traffic, basic stuff. You sitting in an orange jumpsuit. You ain't kill nobody, but you in an orange jumpsuit for some foolishness. Think about what you're doing to waste your life. Think about it. Does this make any sense?
No, ma'am.
Do you have kids?
Yes, ma'am.
If your son did something stupid like this on a traffic offense, dude, all you got to do is pay the fines and send in your little letter and report. And he like, well, whatever. I don't understand. And then he ends up in an orange jumpsuit. Is that something you're trying to teach him to do?
No, ma'am.
Okay, then why are you showing him that that's what daddy's doing? As long as you in an orange jumpsuit, you're not, one, being a father to your kids, two, helping support your kids, because you can't keep a job in the jail. And three, setting a good example for your kids. I love these dads who gonna be out here, let your child do something great. You're gonna be in a bar, thumping your chest, talking about, that's my seed, that's my son. But you didn't help to get them there.
Judge, I think Mr. Barber, like myself, has a daughter rather than not.
Well, that's even worse. Because you know who she gonna end up being with? Somebody who gonna spend their life in an orange jumpsuit. If the example of what a man looks like is what you're doing, she's gonna be miserable.
No, it's not, Your Honor.
Well, what you teaching her different?
Judge, he did just recently, after moving back to Georgia, he does have a good job. He's working at Plaza Security in Atlanta. He does have a place to stay in Atlanta.
Which you have just jeopardized for failure to put a letter in the mail. the whole time you were in Florida for failure to drop by the post office, buy some stamps and some envelopes, and put a letter in the mail, you have jeopardized a good job. This is what I mean. When you do stuff, there are consequences, and you are failing to think about the consequences of your actions. So now you've decided to get a good job and support your family, but you're messing up your good job because the easiest thing I could have asked you to do, sir, put your money and a letter in the mail. You didn't do it. I asked no community service. I didn't ask you to do any of that. You could do it from wherever you were in the world. I didn't restrict you in any other way. Drop a letter in the mail and pay. And now you're about to mess up the good job you have now for the triflingness that you had then. And I'm gonna fuss because I don't want to see you back here. All right, tell me what we stipulating and agreeing to, Ms. Chang, because I'm just done. The easiest thing Mr. Barber could have done, and he about to mess up his whole life, spending time in an orange jumpsuit on some foolishness.
Your Honor, probation department recommends that 30 days be revoked, credit for time served since September the 9th, and close the case.
Mr. Lynch?
Yes, Your Honor. So we're going to ask that you follow that recommendation.
All right. Okay, makes sense. But Mr. Barber, get it together, sir.
It won't happen again, Your Honor.
I sure hope not. Because your daughter does not need a father who goes to jail for stupid stuff. Because when she brings home that knucklehead that she patterned after you, don't you say a word. Don't you say a word. Because this is what I taught you a man looks like. So I cannot say a word. Okay? Just be warned. I'm telling you. One second, my computer's. All right, so Mr. Barber, just I don't know how to emphasize it enough that most of the time when we have troubles in our life, it's because we don't make good decisions. You need to make good decisions because you have a child that's dependent upon you. And so your child does not need to see you make dumb decisions. They just don't. So Ms. Chang, I sent one of the petitions. Do I need to do both? Because I think I had two, but it's pretty much the same, right?
They're all in one petition. Yes.
Oh, okay. I think I may have gotten it twice. Let's see. Yeah. All right. Mr. Barber, you're free to go back with the sheriff's officer. Hopefully you'll be getting out today to get back to that job.
Thank you, ma'am.
Hey, well, he has a job as a security guard, so obviously he's got it all figured out. Over some traffic tickets, I can't imagine going to prison or going to jail over some traffic tickets. So, well, here's one with Judge Simpson. The lawyer in this one, the last time I saw her, she was getting the judge to get on her client to argue with her client that she's a good lawyer, and so I'm not really sold on this attorney yet, and so she's kind of a mess. I think Judge Simpson has his fill of her as well. So let's see how that goes.
Good afternoon. Go ahead. They've stated their appearance. You can state your appearance, counsel. All right. Your name, sir? Thank you. All right. Are we ready to proceed?
Yes, Your Honor. Your Honor, I'd like to make a
Come up to the podium. You'd like to make a motion to dismiss?
yes, or not proceed.
Okay, or not proceed.
Dismiss.
Okay, go ahead.
Dismiss. As a matter of law.
All right, go ahead.
I told the people I was gonna make the motion. She asked me based on what I told her I would let you hear it, and then she can hear it as I speak and respond. But it's based on a case that the people gave me that they were going to see without the complaint. And the statute is going to see that without the complaint. So I do not feel that this is a surprise because I took what they gave me and read it.
Say that again to me.
There is no surprise to the people, in my opinion. I'm going to make a motion to dismiss because the complainant is not present.
Okay.
And they want to proceed without the complaint.
Under 27B.
Yes, under 768, 27.
C.
And just to be clear, if people need only, I didn't give you any cases, so I've never talked to you about
Well,
this.
maybe it
so
wasn't. It was the people. I said
just to make sure that I'm personally not surprised that you have words out there.
So when I say the people, that's what I mean. I'm not.
Right. No, that I get you.
But the people, that's where I got it from. I know who it was, the color. Oh, wait.
Oh, you're welcome to get me mixed up with Jessica Blanche. Totally fine with me.
I'm gonna keep this simple and concise, all right?
Right.
All right, based on the complaint, it's not here, number one.
Correct.
She has made statements to the people and the police. She does not want to proceed. All right, but specifically, if you look at people versus only 3% of the chat 319, that's what we relying on. Because in that instance, the court did let the testimony in. The complainant did not appear. The court let the testimony in. In that instance, though, the complainant had talked to the police officer specifically. She said that the client broke in, was her ex-boyfriend or boyfriend, however you want to look at it, broke in, demanded money that he had loaned her, took the money, knocked her on the floor and strangled her. The police officer observed red marks on her neck and some other corroboration, I think bruises on her, okay? That's totally different. So that is why I believe that case is highly distinguishable from this. They cannot rely on that. So they use the statements that that witness made directly to the officer right under the immediate occurrence of the incident. That's the other thing that's very important. Right after it had happened, because 911 was called right as it was occurring.
I've read it. Yeah.
So you didn't have time for reflection, you didn't have time for manipulation, you didn't have time for creativity, fabrication, or any other thing. And that's one of the protections why this goes to 76827C. If you look it up, it's based upon the court rule, the excited utterance, right? So that's sort of it is.
Well, it's based on that, but it goes a little bit. Yeah,
It's
go ahead.
based on that the incident, that the statement was made spontaneous or in concurrence with the event or shortly thereafter. Present sense impression as well, the state of mind. That might be a little bit longer, but that's not what the statute is. It's like C. If you look up C, it says there must be a sufficiently startling experience, suspending reflective thought and a spontaneous reaction, not one resulting from reflection. That's what the C is based on. Okay, that's not here. That does not exist here. They never talk to the complainant.
That's another point, Your Honor. Could I just ask a simple question? This isn't the unlawful inference, it's just a question.
No, I'm gonna get to that. Then I'm gonna tie it up in a minute. I have to say this.
Okay, go ahead.
That's what she wants you to deviate to, but I say.
Wants me to deviate to?
Well, I'll tell you, if prong one is not satisfied, the matter should be dismissed. What they want to do is piggyback their case on statements that my client made while he was in prison, or statements the complainant made while they were on the phone. I'm saying this case should come in the first place. So now this would be like fruits from the poisonous tree. It's like, yeah, it would be. It's
Why?
Like, I'll tell you. It's
Okay.
like, I had a case once, and police said they stopped the guy because it was a stop sign. The stop sign never existed. I proved that with records in the city, right? Therefore, that was a fallacious reason to have the probable cause. Then it was after the probable cause, fallacious probable cause, they said that there was plain view sight of a gun. And after description of the gun, the weight of it, on and on, I was able to show that that search was a fruit of the poisonous tree or the stop. That's exactly what these calls would be. Because they can't come in because they weren't, as I said, she's not here. And she never talked to the police. Now when you get to the phone calls at the jail, that's much further in time away if you were thinking about it from the date of the incident, which I believe was August 5th, 2024. So it doesn't qualify under 768 2.7C. It's far away in time, and it deprives him of the right of confrontation under the Sixth Amendment. He wants me to, as I close up, it's a serious matter, it's a real argument. He wants you to leave the state on people versus the state Raymond environmental. But it is depriving of this right of confrontation. They leave prong one. Now they want to piggyback on the jail calls, which were far away in time and don't meet the hearsay exception. But I've cited in their case, people versus only or the statute. The violation, it's real law. It's real law.
Okay.
Constitutional right that does not apply to preliminary exam. The Sixth Amendment is a trial right. I'm speaking now with my time. Thank you. Last time I checked, we were not at trial. The preliminary exam is a statutory right. People the only specifically states the Sixth Amendment does not apply at the preliminary exam. I don't know who told Ms. Ford that I'm moving forward under 27C today. This is not a 27C case. And if I had just had the opportunity to ask my question, we wouldn't have had to sit through that entire argument. My question is, at what point in Pittsfield Township Police Report number 24-16611 do you have a victim statement in there? Because the victim statement is what allows somebody to move forward under 27C. I am not moving forward under 27C. This is an assault that occurred on video. I don't need the victim statement for me to play the video of him punching her in the face and slamming her back into a vehicle and then speeding away while she's trying to exit the vehicle. Then he confesses to the officer. So his statement that I will be admitting as a statement against his interest under the Michigan Rules of Evidence is how I'm moving forward. That's not 27C. What's also not 27C is his witness intimidation. While he is in the jail, calling the domestic violence victim from the jail, telling her, call the prosecutor, tell them you don't want to move forward with charges. Did you talk with the officer? What did you tell the investigator? And she says, you bet I did. That's not 27C either. That is also non-hearsay statement against the defendant's interest. I'm ready to go.
Just briefly, as I said, that I've said pretty much what I had to say, that this statement cannot come in independently.
Which statement are you talking about, counsel?
Any statements by the complainant cannot come in without the complainant's testimony in this instance. Or a legitimate
hold on, counsel. So I'm pretty sure we're talking about the right case, because you started out with a 27.3 or 27C argument. But my understanding when I hear from the people is this isn't a 27C case, that there is video and then the alleged statements that are underlying the primary case. And when I say the primary case, 1055, the unlawful imprisonment and domestic violence.
So the statements were made at the time of the event.
Which statements?
Defendant's statements. He didn't give a statement. And so the statement.
Yes, he did. That's what they just said.
Officer Welker confessed to the crime. She's going to testify to that today.
That's what I understand.
Hold on, Mr. Epps, hold on. I just want to make sure we're all operating off the same page, because what What I understand is, Ms. Ford, hold on, just folks, I'll let you have your conversation. I just want to get out what I want to say. My understanding is this isn't a 27C case, that at least what they're alleging, and I've not heard any testimony, so I don't know. I'm hearing what they're telling me at this point is that there is video evidence of the defendant committing certain acts. That then subsequent to that, there is then an admission to a police officer as to those acts or some portion thereof. That's a whole different thing than 27C and having that. May I also then say, it seems to me that part of your argument was going then to, I'm presuming, jail calls or other things in which the defendant would have said certain things. This is how I'm envisioning this, and I may be slightly wrong interpreting it. That there may be responses from the alleged victim in regard to what the defendant may have said. Again, I haven't heard it, I don't know. But if that's the case, and there's statements in which she may have said, well, and I'm just giving this as an example, I'm not saying it's what it is, that he says something, she says, okay, you're right, I'm not going to show up, or I'm not going to do something, or whatever. That's, and then she's not here, or even actually his act of doing that, depending on what it is, really constitutes the second case. So that's where I think there might be a disconnect as to exactly where this is heading. I don't know, because I'm not involved typically in conversations that council's having. I don't know what may have been told to you by somebody before, but I'm presuming you had the discovery package and could see what was there.
Correct.
So I would anticipate that without the victim being present in this case, that the people would be proceeding with video evidence of these alleged acts, and then the officer's testimony of the defendant's statements. And then if that proceeds, then there's then the stuff that occurred afterwards.
Thank you.
So regarding your motion, I would have to deny it. Do you wish, before you leap over there, Mr. Evans, do you wish to have time to go back and talk to your, that was a lot there. And I don't know, I saw Mr. Epps trying to talk to you first, and then I kind of stopped him and then did whatever, but I want to make sure he has time. You want it played?
Yeah.
Oh, have you seen it?
Yes, sir.
Okay.
Is that a stipulation to its admission?
Are you stipulating to its admission?
Yes.
There's, okay, so I just want to be clear, Mr. Epps, you don't want time to talk to your counsel about what just happened and what I just, because about how they're going to proceed. I get you get the video part, but the other part of it, I don't.
What my understanding, what you're saying, a case is built off of video. I already saw it.
Well, no.
Well,
It's
the
built.
video show this alleged,
Okay, this is part of the problem, Mr. Evans. It's not that I won't hear from you, you know that. It's just that I don't want you saying something that might be used against you.
Oh, no, I know what you're saying, I know what you're saying.
Okay, but that doesn't always do it. I'm just saying, when you say to me that their case is built off of that, there's another big piece to that, and that's supposedly your statement.
Okay, and I understand that too.
Okay. And then that there is, then that's that first case. And then there's the next case of what may be, I'm presuming, statements by you on the other case, the bribing intimidation.
And so, I wanted to ask you,
Yes, sir.
I know my Sixth Amendment. It's my.
Hold on. Hold on. Yes. And here's what I'm gonna do. I'm gonna take a break. Have you taken back? I want you to, because you're asking questions. I could certainly answer them, but I'm not gonna step in between the attorney-client relationship. And so I want that question, I want you to talk to your attorney about that. When you start getting into that issue. Because certain things you may think apply at this proceeding may not apply, but I want you to get your attorney's advice. So what we're gonna do is let's take Mr. Epps back, let's get him, and then Ms. Ford, you can go around and talk to him and answer any questions that he might have regarding that.
I want to answer one question. He has not heard every single jail call from me, but he has.
What do you mean?
I read the jail call.
There's a written statement summarizing the jail calls. The victim of voice mail of the jail calls, I guess, he has not heard everyone. I saw him, but they're extremely voluminous. So he is ready to proceed. He knows what the jail calls say. Well, number one, he was honest. But number two, there's a summary of it in the discovery. So he has seen all of that and he still wants to proceed. Is that correct?
Okay. You're still gonna need to ask that other question, answer his question. So I understand that. Can I just say this so we don't run into a problem? I realize he saw a transcript of calls, right?
Yeah.
Okay. Can I just ask, and I don't know whether it's a case of maybe you know, maybe you don't know. Are those the transcripts that he saw? Are those the calls that the people are proceeding on as part of the case?
Yes, the jail.
Well,
Yes.
okay, I get it. But my understanding is that there are jail calls that he has not heard, but he's read.
Yes.
And that he wouldn't have read all of the jail calls because were all of them transcribed?
Not every last one.
Okay, so then my question becomes, are the calls that the people are relying upon for the case, he hasn't heard any of them, I'm presuming, right? But has Mr. Epps been provided the transcripts of the calls that the people would be relying upon to form the charge?
Yeah, I did talk to the people yesterday. They said they may or may not use any of the specific calls. They may use the summary of the calls.
The answer to your question is yes. Every jail call that I will be using today is in the police report that's been provided to them. I understand he's read that.
And he's read that, okay.
Because we did discuss that yesterday.
Okay, I'm trying to make sure I'm not part of those conversations, so I'm just trying to make sure Mr. Epps' rights are protected. All right, let's take him back, let you talk to him. I'll try to handle the other case, and then we'll come back out and try to do this. Whenever they can bring him out.
You don't have that many. We're just very many.
Don't sound like that.
Yes, you do.
Don't ask.
You sound like, Alan said you sounded like a squirrel that had its tail kept stepping.
Oh,
I'm just
yes,
saying.
please. Bye-bye. Alan, how'd that bus feel as we just ran it over you?
Say nothing, man. This is all use.
30 days, yeah. I guess that would make it simpler, and then we'll understand that. Do an application for actual treatment, work with each other, maybe in charge of probation, follow all the requirements of certain probation. So that was,
It's all right. I'm gonna step off there. All right. Just let my staff know. And took a left turn. All right. So we get Mr. Green out. No. Yes, I got it. She's gonna have to sign it there and then come up to the podium. Plea form? I do not. Court does call the case of People versus Cedric Green.
Christina Costantino on behalf of Mr. Green.
All right.
And Your Honor, this is the date and time set for an exam. We have reached a resolution in which my client will tender a no contest plea to second offense and attempted resisting and obstructing. There's also a sentence agreement in that matter for no more than 30 days in jail with a probationary sentence, no delayed or deferred sentencing. I believe no contact as well. Correct?
There must be a no contact order. Is that what you're saying? Yes, there must be a no contact order, but the final thing that's written on here is the defendant must accept responsibility for his circuit court violation hearing scheduled this summer.
I missed that one, but yes, that's correct in our understanding.
All right. And just so that the parties are clear, because I would not be the sentencing judge, I can't bind the district court judge to the sentencing agreement of the 30 days in jail, but I don't see why the court would follow it, but I can't bind that. I can't make that a promise that I'm making.
Understood.
Got that?
We're ready to go forward.
All right. May I have it sworn?
You solemnly swear in front of testimony about the
All right, Mr. Green, this court's understanding that you are going to be pleading no contest to 2 added charges, and I think it's 7 and 8. The 7 being domestic violence, second offense. That's a misdemeanor punishable by up to 1 year incarceration, a $1,000 fine plus court cost. And also to attempted resisting and obstructing, that being count 8, which is a misdemeanor punishable by up to 1 year, $1,000 fine plus court cost. You understand that, sir? All right. Do you understand what a no contest plea is? All right. 2 things about it I have to make sure that you understand. First thing you have to understand is that it means that you're not further desirous or wanting to contest these charges. You understand that? Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that? All right. You also understand, sir, that while I'm taking your plea, I would not be a sentencing judge in this case, and you would be sentenced before Judge Perry in the 15th District Court. You understand that? All right. Now, understanding all of that, sir, do you still wish to plead no contest? All right. So to the charge of domestic violence, second offense, how do you plead? To the charge of attempted resisting and obstructing, how do you plead? Now, you understand that by pleading no contest, you'll not have a trial of any kind. All right, you signed an advice of rights for today, is that correct? Do you have any questions regarding any of those rights? All right, on the podium, please look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty or pleading no contest, you're giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? All right. You understand that your plea in this case could be a violation of that probation. You understand that as such, that other court could sentence you to the maximum allowable under those other charges. Oh, well, do you understand that?
Sorry, Judge, he's a bit confused because we've received a recommendation from probation.
Got it.
For the violation of probation, so we have an idea of what he might receive as a sentence in that case. But Mr. Green, you understand that this case will constitute a violation of your probation, right?
Outside of that.
Well, they've already violated him, Your Honor.
Correct.
So you understand that this pleading guilty here is a violation of probation. They've already violated you.
4 days.
Yes.
You got that? Okay. You understand the important part of that is you need to understand that while you've received a recommendation, the court could sentence you to the maximum allowable under that charge.
The circuit court could do so. We've received a recommendation. We have an idea of what the court might do, but Judge Simpson can't tell you today what that court will do. So that court could sentence you up to the maximum allowable under Michigan law. Mr. Green, that's correct. We have discussed that. It's a recommendation. Which is what recommendation.
Mr. Green, let me just say this, that the court always reserves the right to sentence in the way it sees fit, right? Whether it be this court or another court, we have that right to do that. When you receive, we will receive from either our probation department or probation typically, a recommendation of what the court should do. Okay, that happens virtually in every case, right? What I'm advising you of is should that court choose to not follow that, the court could do something else, all right, which could be the maximum on that other charge. It could also be that the court says, I'm not doing anything. It's what's important though is that I apprise you of sort of the maximum thing that the court could do to you. That doesn't mean it will. I have to apprise you of that. Now, if you are confused about that right now and you need additional time to talk to your attorney, I'll let that happen because I don't want you rushing into anything that you don't fully understand. So.
Okay, I believe my client's ready to go forward, Judge.
All right. Are you, sir? You think you've had an adequate time to talk with your attorney regarding this? Okay, so I'll ask you the question again. You understand that I understand it already has been considered a violation of your probation. And you understand that as such, by the entry of the plea, the court could sentence you to the maximum allowable under those other charges. All right. And understanding that, sir, do you still wish to plead no contest? Has anybody promised you anything other than what's been stated here today on the record, which would be that counts 1, 2, 3, 4, 5, and 6 would be dismissed? Has anybody threatened you or coerced you in any way? You're doing this voluntarily and of your own free will. All right. Court has been provided and has partially reviewed Ann Arbor Police Department report for their case number 24-36705. Any objection to the court reviewing that report?
No objection, Your Honor.
Thing I don't have, and we can solve that. You do stipulate to the prior domestic violence, is that correct?
Yes, Your Honor.
All right. Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of these offenses. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's no contest pleas to counts 7 and 8. Counts 1, 2, 3, 4, 5, and 6 are dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in this matter will be
October 2nd at 10 a.m. before Judge Perry.
October 2nd, 2024. What time?
10 a.m.
10 a.m. before Judge Perry. Bond will continue.
Thank you.
All right, thank you. Thank you, Mr. Green. Good luck. Ms. Constantino, always a pleasure.
Always a pleasure, Judge.
Waiting? Did she seem to care? Probably not. Okay, so I'm going to stand in brief recess. Everybody can remain. Okay, are we ready to proceed on apps?
Yeah.
Here we go. Can you bring it up, please? Court does call the cases of the people, state of Michigan versus David Epps. Thank you, sir. Date time set for preliminary examination. Are you ready to proceed?
Yes, Your Honor, thank you.
All right. Let me call you first witness.
Thank you. I'll start by calling Officer Whitener.
Take a seat, raise your right hand, and solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God. See, name, spell your first and last name for the record.
Officer Jessica Welker. WELKER with this department.
Thank you. You may inquire.
Thank you, Your Honor. Officer, where are you currently? Thank you. How long have you been employed as such?
Pittsfield, I've been employed there since October of last year, but I'm officer in over 10 years.
Prior to Pittsfield, you were with Ypsilanti Police Department?
Yes.
Thank you. Were you working in your capacity with Pittsfield in July of 2024? Specifically on July 28th of 2024?
Yes.
Are you familiar with the address of 5550 West Michigan Ave? In Pittsfield Township, Washington County, Michigan?
Yes, ma'am.
About that address.
That's the intersection of Michigan and Carter.
How did you come to be involved in this investigation?
I was on work for that day and inspection myself at McDonald's. Initially based on dispatcher information, we were dispatched to the one a little bit farther up north on Carter. But based on the description of there being construction, we realized now that on the Sam's level Carter and Michigan Avenue.
So for instance, you had the opportunity to arrive on scene of this McDonald's. When you arrived on scene, was it approximately 2:07 p.m. or around that time?
Yes.
When you arrived on scene, did you have contact with someone by the name of Shanora Harris? To this point in your career as a police officer, how many times have you interviewed Shanora Harris in person?
I knew Ms. Harris from Ypsilanti PD, so I can, end up there, but as far as interviewing her on facts of this case, I didn't.
Thank you. Did you make efforts to interview her?
Yes, I called her to, verify her welfare and answer or to talk to FaceTime to speak with her about things and she refused.
Thank you. When you arrived on scene at the McDonald's on July 28th, 2024, did you have the opportunity to speak with witnesses? Specifically one male witness?
Yes.
Without telling me any of the information that he told you, did you also have the opportunity to speak with staff members at the McDonald's?
I did.
When you spoke with staff members at the McDonald's, did you make any inquiries about Shanora Harris? Meaning, did you ask them any questions about somebody named Shanora Harris?
No, it was presented to me.
Thank you. Did you have the opportunity during your investigation to look into surveillance footage? Why?
Excuse me one moment. Can you call Mr. Banner? Go ahead.
Why did you look at the surveillance footage?
Based on the allegations, and without really direct statements made by the agency, there's a solid allegation. Therefore, I requested surveillance footage of the business on the outside, where the alleged incident was supposed to happen, and was able to obtain.
Did you understand Shanora, employee of that McDonald's?
After interviewing some of the other employees, yes, that information was provided.
And did you have the opportunity to review surveillance footage from that McDonald's as it relates to July 28th, 2024?
Yes.
When you reviewed the surveillance footage, where were you initially?
For reviewing the footage, I went to the location with one of the detectives, reviewed the footage there, with the employees, who gave input, which is what led to get information from Ms. Harris, as well as after the fact, had a decision.
Were you present when the video was being downloaded or extracted from the McDonald's?
Yes, I was.
Thank you. Your Honor, I am plugged in. How do I get connected to this?
Got her. You are connected.
Thank you very much. Officer Walker, can you see the screen?
Yes, ma'am.
Are you familiar with what is presently on the screen?
Yes, ma'am.
Could you please describe to the court what this is?
Of course. This is a pole cam that faces the parking lot of the 5550 West Michigan Avenue McDonald's at intersection of Carpenter Road and Michigan
And the screen that I have it stopped on, have you had the opportunity to watch the video from this point forward?
Yes, ma'am.
And is this a fair and accurate reflection of the video that you took into evidence as part of this investigation?
Yes, ma'am.
Your Honor, at this time I would move to admit People's Proposed Exhibit 1.
Any objection or voir dire? Okay, and I've already ruled on that. Is there any objection to this piece of evidence coming in? Exit. So that the record's clear, I've already denied that, so I hear no objection. Exhibit 1 is admitted.
May I just place on record to say more that it would be a continued objection? I want to say.
And my ruling will be a continual one of the denial. Go ahead, Ms. Hughes.
Your Honor, may I have
Yes.
understanding of who the person is that was dragged and put into that vehicle?
Yes, ma'am.
Who is it?
Nora Harris. Your Honor, I would just like to place an objection like a foundation to identify who either person was in that video.
Certainly, I can lay that.
Yes, go ahead.
Did you have the opportunity to interview somebody by the name of David Epps?
Yes, ma'am.
If you were to see Mr. Epps again, would you recognize him? Is he present in the courtroom today?
Yes, ma'am. He's sitting next. He's sitting next to his counsel.
Thank you. Your Honor, please let the record reflect the witness identified the defendant.
Without objection, record shall so reflect.
Did you have the opportunity to interview the defendant?
Yes.
Where were you when you interviewed the defendant?
It's not so much of which part station one.
Thank you. Was the defendant in your custody at that time? Prior to the interview beginning, did you read him his Miranda rights?
Yes.
How did you do so?
I read the Miranda and I reviewed them and decided next to individual rights as well as a follow one. Best if you have enforced force or threat in any way.
At the conclusion of reading him his rights, did you understand that he was waiving his rights and wished to give you a statement?
Yes.
Did he give you a statement acknowledging that the person that was put into the vehicle is Shanora Harris?
Yes.
Did he give you a statement acknowledging that the person that put her in the vehicle is David X?
Yes.
So going in order of his statement. So first, I apologize if you already said this. Did this interview occur on August 1st, 2024?
Yes.
Thank you. At the beginning of your interview, did you indicate what you were there to speak with him about?
Yes.
At this time, when you started the interview with him, did you know Ms. Harris's whereabouts?
I did not.
Did you have any concerns about her whereabouts?
I did.
Could you tell us about that, please?
Yes, go ahead.
Starting with the timeline of the incident, that's all right, I can kind of explain in the foundation for it.
Thank you.
The incident happened on July 28th, at McDonald's, and that was the last time that anybody had, like, I saw her. We had her on camera, and that's the last time anybody could say her name. According to Mr. Epps' statement, he claims that that's the last time that he saw her, and they got into a conversation verbally, and then they broke up. After that, on the 30th, her items, her social security card, various items ID were located on the scene of a shooting in International. And we couldn't find her.
May I interject one thing? Does she have a statement where it's sworn in his handwriting where he's written that and he's signed it?
No, ma'am, it's on camera in the interview.
I'm going to just continue.
What are you objecting to, though, counsel?
I don't see a signed statement of him. But I know I don't see a signed statement. So that's.
Okay, but have I'm sorry, the interview or statements that you're relating are on video.
Yes, Your Honor.
Have you been provided a copy of that video, counsel?
Yes, I got discovery. It didn't all pop up. That's
Well, what does that mean?
some of them pop up, the pictures pop up and some don't. Really, like push to see various parts of discovery, some pop up, some don't.
Okay, but here's my question. With reference to the statement that the officers testifying, which you're objecting because it's not in writing, did you receive, you have what?
I have a summary of it right here.
Okay, I understand that. But did you receive a copy of his video statement?
I got to discuss.
Not my question, counsel. Did you receive a copy of the statement?
Yes.
Has your client had an opportunity to see that statement?
Yes.
Okay, I can't. Let me ask you this, because otherwise we're going to run into this at every stage. Has the discovery that you received, has that been shared with Mr. Epps?
Not all of the videos.
So what videos haven't been shared?
I saw the one, that we could play, sir.
Okay, got that. So there's a video of the statement.
But I did not show. But he knows it in terms of the business, but not the videos.
I got you. Just stop. So, counsel, you can't, the officer's up here testifying. You're objecting because the statement isn't in writing.
Right.
But you're not objecting to at least the substance of what she may be saying.
That's correct. Before we got started, I did mention to my client that certain videos he had not seen, I asked him.
But hold on, counsel, I'm gonna stop you. I'm gonna stop you right there. When we were going through your previous argument, one of the issues that you were trying to say it was a 27C case that Ms. Hughes specifically brought up was your client's statements. And so if you knew counsel, don't you think your client should see what he's telling me? He doesn't have any idea that it was recorded. I don't know if that's true or not. It doesn't matter. Because the thing is that clearly that's evidence against him. Would you not agree that he should at least see that? He may not like it, he may not whatever, but he should at least see it. Not right this second. I'll hear from you, but just not right now. Okay. How long is the statement? An hour.
At least the recording.
Right, but the recording of his interview is okay. All right. Hey, what do you want to say, Mr. Epps?
I didn't have no knowledge, and I don't think she had no knowledge of the video. This is just coming out today. That is
Had no, say that second.
knowledge of a video. This is just coming out today, sir.
Well, hold on. I don't mean, I want to make sure I understand what you're telling me. I hear you that you're saying you did not. And then you're saying that you don't think counsel did.
No, but this is just coming out today that it was video.
I shared a video with Miss Ford on August 9th, 2024, and it was downloaded, and she still has another 52 days left if she wants to download it again.
Excuse me, go.
No, that, yeah.
Sorry, you're on a minute. Approach the witness for just one moment.
You may.
Thank you.
So I don't know that I can. Mr. Epps, I don't know where I can answer your question, the second part. I hear what you're saying, but I don't know that I can answer that. All right. The only thing I am concerned about is, Ms. Ford, whether you knew about it or not, because I don't know, and I'm not going to get into that at this point. Wouldn't you believe that at a minimum right now, as we sit here right now, that your client should be entitled to see that video?
Yeah.
Okay, folks, Officer, you may step now.
Thank you.
All right, I'm going to adjourn this. I want every Miss Hughes, you indicated that that was sent to council. All right, Miss Ford, do you still, hold on. Do you still have a copy of that? All right, but no, just stop. That video is to be shown to Mr. Epps. Now, how many other, Mr. Epps, you said you saw the one that we just saw, right?
Yes.
All right. How many other videos were sent?
16 videos were sent and 4 pictures were sent.
So 16 videos, 4 pictures.
Yes, separately, there are jail calls as well that are, I sent directly to her by email.
Okay, I'll get to that that's on the other case. All right, so Mr. Epps, let me ask you this. Of this, I'm just trying to think of the correct way to phrase it. How many videos did you review? Let me put it that way.
I reviewed the one that we just saw, and I heard phone recording.
Hold on. I don't want to get into phone recording. I'm talking just about videos right now. How many so what I'm hearing from you, you've only seen one.
Yes, sir.
Okay, so that's. He's got to see the other ones. Some of them may not mean anything at this point, but certainly if they're proceeding on his confession, then he's got to at least see that one, but he should see all of them, or at least have the opportunity to see all of them. Those videos all relate to the case ending in 1055. Is that correct, Ms. Hughes?
Yes.
Okay. Now there are also, and we were kind of getting into this before. He's seen the transcript of phone calls, but Mr. Epps, I'm going to ask you again. You haven't heard the calls.
Yes.
Pardon?
Yes.
Okay, I asked the question badly. Have you heard any of the calls? Okay. The ones and you may or may not know this, the ones of the transcripts that you read, did you hear those calls?
Yes.
Okay. But you haven't heard all of them. So let me ask you this. Is there some of those calls that you're reading what the call said, but didn't actually hear the call?
What's that?
Was that correct, what I just said?
Yeah.
Okay. Okay, so Ms. Ford, how many, I don't want to put it that way. Is there a reason why the calls themselves have not been provided to Mr. Epps to at least hear?
None other than I saw him and I told, their calls last for hours and I told him they lasted a long time. We discussed what they said, but other than that, no.
Okay, so let me ask this. I realize the calls may last for a long time, but and so that there may indeed be calls that he just doesn't need to hear. I mean, whatever, because they're not going to really be part of the case. But has he heard the recordings or had an opportunity at least to hear the recordings of the ones that are transcribed?
No. There's about 11, no,
Okay, there's about 11 calls. Is that what you're telling me? While it may or may not be important, those 11 calls, the transcription of those 11 calls, are they accurate?
I believe so. I believe that. The client can't say because he hasn't heard the direct call.
As to the calls, because we kind of dealt with this earlier, Mr. Epps. Mr. Epps, did you want an opportunity to hear those calls and to attempt to try to verify those calls as against what you read?
I wanted to call Plea in court, so.
Well, do you know what they say? So let me ask you this. Why would you want them played if you're not sure what they say? And I'm just saying this, let's say what you read is not what's on the call.
Yes, sir.
Why would you want that played before you can hear it yourself as to what I'll hear?
Sir, I had, I'm currently on parole right now.
Right.
And I had, they have an evidential hearing before you go to your immediately, your hearing.
An evidentiary hearing before you go.
To your immediate hearing.
Right.
Against the charge, alleged charges that I'm facing. So, the call is very vague.
Right, okay, stop, can I just stop you there?
Yeah.
Right now? Because you're not gonna have that type of evidentiary hearing before this proceeds. I see why you say you want to play in court. I get it. That's not the way this procedure works. Okay, so if you, and what you just said, that you think the calls are vague and may not mean what they mean, it's going to be important, frankly, for you to hear the call. I would agree with you that sometimes on paper, something can say something, but be said in a way that that's not really what's meant. I think that's what you're trying to tell me when you say vague. Is that right?
Vague, when I say vague, meaning that you can't hear it, like you can't hear.
So they're faint.
What's going on?
So hold on a second. When you say that, what's on the paper that you read then about the call? If you can't hear it, huh?
Yeah, you like, when I'm doing my interview, my parole interview, they play it on the screen.
Hold on. You're at another hearing I'm not part of. So were these phone calls part of some other hearing?
Yeah.
Okay, so at some point you heard them?
Yeah. But it was, like I said, you barely can hear him, you know what I'm saying?
So in other words, hang on, I got you. So in other words, some of you have heard, but you're not sure then what is transcribed is what the written part is what's on those tapes.
Yeah.
Which is why you wanted them played, because you think, okay, I got you. Not a good way to handle it, but I got what you're trying to tell me. All right, this can't go this way. So, I mean, even if one were to say that he doesn't need to hear the phone calls, and one might argue, or he's part of the phone call, so he knows what they say. I mean, maybe that argument could be made, but there's going to be no excuse for him not seeing the videos. None. Seeing all of the paper discovery against you, Mr. Epps?
Yes, sir.
Okay. So I just wanted to make sure. Okay. So here's what I'm gonna do. I'm gonna adjourn this case to October 8th. Counsel, I don't care how you have to do it, what configuration it needs to be done in, or how you need to arrange that with the Washington County Jail. But you are to arrange so that if you got, I don't know how long these videos are, but if there's 20 hours of video, you're gonna sit there 20 hours and make sure he has access to those videos and can see them, as well as that he has access to the phone calls. I am not going to accept as some type of an excuse that there might have been some difficulty with the jail or some issue in terms of that. I'm not going to accept it. If you got to sit there all day and night till you get in to see him, you're going to sit there all day and night till you get in there and see him, and he gets a chance to see it. He may not even like what's on the video, and that's fine, but he should at least see what's being used against him.
Understood.
I would like counsel to withdraw, please. I went over this several times with her, about this video. And like she said, she complained that the video was long, you know. I knew it was appropriate to see that this video, and I asked my counsel several times, could we see this video? Could we go over this video? I also told her the proper way to let me see the video, that she will have to bring a laptop in, because I've been through this before with a prior counsel, you know, and it's just like, right now, I'm embarrassed because it looks like my case is just all over the place. Me and my counsel, like, we weren't even ready.
I didn't complain it was on, but he's right, I didn't bring in the laptop. One time I did, actually, one time I did.
You understand if I do that, Mr. Epps, that this would further delay your proceedings?
Yes, sir.
You understand that that's a possibility, that it'll be further delayed?
I don't want no delay. So I guess I'll just go ahead with counsel.
Well, Mr. Epps, I wasn't trying to lean you one way or the other. I'm just trying to. Dear God.
It just seems, Your Honor, we just came in here.
Mr. Epps, I'm hearing you. Okay.
He hasn't seen all the video discovery, there was a firm plan I found.
Pardon?
The gist of the plan I have found, he has not seen all the video discovery, that is correct.
I'm acutely aware of that. Today is what? Well, all right. Let's do this. Let's take Mr. Epps back. Mr. Epps, I'm going to think about your request and that whole issue of delay and see that. Give me a minute to try to make a decision on that, okay? Because it's.
One thing on your radar is continued use of the jail calls, just to put defense counsel on notice that I will be addressing that when we come back.
Whoa, what?
He has continued to call the victim of the jail.
I just found that.
Oh, okay. Yeah, thanks, because there wasn't enough on my radar. I do appreciate it. I do appreciate you.
Like the cliffhanger.
Court's gonna stand in recess. Yes, sir.
Because he has a lot of stuff. We should look at it.
All right. See you next district.
Thank you, Ms. Rose.
You're on the next day.
Yes.
We've talked, I thank you for your time. We've talked a lot. And, mostly amicably. And at this time, I do not believe, we both went back on this matter, whether that actually is lawyer, in my opinion, if we both went back and forth. But in this last session, he told me he thought it was best that I not be the case, and I'm just going to agree. This is the first time. That's what he wants, a battle plan. When I say I think, that's because I know the various ways of matters can go. To him, that's weak. To me, it's insightful and knowing very a bunch of nuances and not promising something's gonna go one way, when I know good darn well, it can go sideways, or it can go in another direction. So I have a difference in style that doesn't meet that right there doesn't meet his need. He needs a battle plan. Someone say, let's try to just win this war, period. Whether we win it or not, that's not my style. So between all those reasons, he deserves what he wants. There are lawyers that will do it. He deserves it.
All right. Okay. Yeah, well, let me just say this. Sometimes I think that, having been a practicing attorney myself previously, that I think sometimes clients have a greater expectation. And I think that's what you're getting at, Ms. Ford, about things. And about what can happen. Having to apprise a client of the particular risk. And then saying that something is going to go exactly along a certain lines. And that's not the way the law works necessarily. And I think, in all honesty, when I assess it, when I look at it, that neither you two just aren't good for each other. And it may be because of what Ms. Ford says, that you want something definite. Just in the little bit that I've listened to, that's not going to happen in this case, right? But maybe you could then maybe have closed the gap between each other had you looked at everything. Maybe not. Maybe you still wanted it to go a particular way because you've got a lot of risk here. And maybe sometimes, I'm not saying that you've done this, but sometimes clients get locked in that they want this resolved. And regardless of what you're looking at, that happened. That you're looking at it, but you're not seeing it. Okay. So I don't think all of that matters. I'm not here to try to attribute blame to anybody or anything along those lines. I just have to, my job is to try to make the proceeding fair, regardless of whatever the outcome is. I just got to make it fair. So, yes, Mr.
I'm just saying, if you're telling me they can do, if you're telling me you can do such and such, and I ask you to show me that in black and white what the law says, I expect to see that, sir.
Yeah, but Mr. Epps, it doesn't work that way. That's partly what I'm saying. I could sit there and show you something that is black and white in the law, but what people don't understand is whether or not that black and white that you're looking at is going to apply is going to depend upon what the facts are that are leading up to it. And so sometimes it may look like it doesn't, that it applies, but it doesn't apply. And there are reasons why, and some of them are very nuanced reasons as to why it doesn't apply. If it were as easy as what you said, we really don't need lawyers. Because I could just, well, you don't need anybody. I just put these facts into a computer and say, this is the result. That's not how it works. And it doesn't work that way for a reason, which I won't necessarily go into, but you know, all cases have their nuances and their little pieces to them. One change in something can change the result on the other end. It would be, quite frankly, in a lot of cases, and I won't say malpractice, but it would be wrong for an attorney to say, here is the absolute result.
Not saying it'll get lost, I'm asking her to show me how to law. I came to her, sir, and said, I got the right to face my accuser, sir. Here it is.
Right, but can I just say that? Can I just say this? You're right. You have the right to confrontation, but did you hear the case law that applied? And that is, hold on, because that's what it says. But then there are certain instances where that doesn't apply, like a preliminary exam. I mean, and there are reasons behind that. And, you know, everybody wants a simple answer, but it's not always a simple answer. It's just, that's just the way it is. But I'm going to give you your wish, and I'm going to give you Miss Ford's wish.
We're also dealing with love, I believe. And it's hard for most defendants to concede that there could be a conviction if a complainant doesn't want to go forward. It's inconceivable.
I know.
And the law is nuanced in this, especially in this area. And I feel I'm up against a brick wall kind of at the end of the day, that I might not be able to make it black and white. And I'm sorry to leave this.
And no, but here's the thing. Here's the thing, Ms. Ford. And this is again what a lot of clients don't understand. They're looking at something in black and white. They get what it says. And I think you're right. I think Mr. Epps is very intelligent. And he sees what it says. The problem is, and some of this doesn't in some ways make sense, but when you read that, that's not what it necessarily means by just the ordinary thought of what you're reading. It may mean something different, and then it means something different depending on what part of the proceeding you're at. You know, like, yeah, you say you have a right to confrontation, but guess what? You don't, at an arraignment, you don't have that right.
Understood that once the prosecutor said that.
I said it all last night and many other times. Oh my God, it's time for me to go. My time is, oh my God. Let's move on.
All right.
I'm not here to argue with.
I'm not here to argue, but I'm here to clarify. So before I can do any more clarification, I think I should
just everybody just hold on. Everybody just have a seat. Mr. Epps, please. Miss Ford. So here's what I'm going to do, Mr. Epps, because this is your proceeding. I'm going to, on the court's own motion, that way I'm not granting your motion. I'm going to do it on my own. I'm going to give you new counsel. I'm going to relieve Ms. Ford of her obligation in the case. I'm going to give you new counsel. It won't delay it, because that was the other issue. It won't delay it any more than what I would have had to anyway regarding the discovery issue. So it'll be October 8th, 2024 at 9 a.m. before me. I would just caution the people that while we've taken some testimony, because new counsel's coming in, and just to be fair, that we'll probably start over. We didn't get that far in on that. And the court, and I'm going to sign the order later, but I'll order it now, that the court will appoint David Burgess to represent you in this matter. he's already aware of it. He's already aware of the date. So he may, knowing him, he's tied up in court, otherwise he would have come down. I'm sure, knowing Mr. Burgess, he'll get to you. So when he shows up, don't think that it's maybe somebody you don't know, but that's him. Okay, but he'll be down to see you. Okay, and at this time, Bob, thank you.
All right, that's about done. Thank you guys for watching tonight. That one was a long and drawn out one, but it had an exciting ending there. Every time I've seen that attorney, there's something wrong with her. I don't know what it is, but I would certainly hate to have her on my team at the end. We're gonna send over to Kitchen Court Chats. She just started about 6 minutes ago. So you guys have a great night, and we'll see y'all tomorrow night.